Hello there. In today's session, let's try to understand why there is a need to unify private international law of different countries. Before we jump into the video, kindly take a moment to like, share, and subscribe to my channel. It means a lot to me. We know that each country is having its own private international law. It's the municipal law of each country, internal law of each country. So country A's private international law is definitely different from country B's private international law, which means that private international law itself can contribute to conflicting judgments. Therefore, there is a need to unify the private international law and rules across the globe. Now, this does seem a little bit convoluted. Let's take two case laws to understand this in a much looser manner. Let's start with Narashima Rao versus Venkatalakshmi case, which is one of the landmark cases as far as India is concerned. This is a case that happened in 1991. Remember the year. The facts of the case are somewhat like this. A couple get married in Tirupati in 1975 and they begin their matrimonial home in India. But 4 to 5 months later, the husband gets a job in USA and he goes to New Orleans. The wife later on follows him. They live there in USA for a short duration of a time. In the meantime, the husband changes his job to Chicago and moves there, but the wife, with a difference of opinion, leaves back to India. The husband decides that he is going to file for divorce, and instead of filing for divorce in Chicago, he moves on to yet another state by name Missouri. He lives there for 90 days. Based upon his residency, obtains a domicile there and files for divorce in Missouri. When the wife was served the summons, the wife promptly filed a petition saying that she was not submitting to the jurisdiction of the Missouri court. In spite of that, the Missouri court decided that it is going to take up the case and it granted divorce on grounds of irretrievable breakdown of marriage. After the grant of divorce, Narasimha Rao underwent a second marriage, which left his first wife filing for both restitution of conjugal rights as well as a case for bigamy in India. The same was dismissed by the lower court based upon the foreign judgment which was submitted by Narasimha Rao in the trial court. But an appeal was made before High Court. This High Court judgment reversed the order of the trial court. And from there it moved on to Supreme Court. Supreme Court upheld the judgment of the High Court saying the following important things. First and foremost, the foreign court is not having a jurisdiction because the foreign court where the case was filed was not the matrimonial residence of the couple. Then, the second point that was pointed out was the domicile that was obtained in Missouri was fraudulently obtained. Now, as far as domicile is concerned, to understand the nuances, I have posted yet another video. You can have a look at it if you are interested. The court pointed out that the husband had stayed in Missouri only for 90 days, based upon which he had obtained a domicile certificate, even though his job was located in Chicago. The next point that the court pointed out was that since the couple got married under Hindu Marriage Act, the divorce should also be on basis of the Hindu law and not on basis of some American law. Under Hindu law, irretrievable breakdown of marriage is not a ground. Therefore, based upon all these points, the court said the divorce is not valid. And the court also pointed out that to recognize the foreign judgment, a certified copy of the same is required and not a Xerox copy. Based upon all these conditions, the Supreme Court said that the judgment of the High Court is valid and that the husband has committed bigamy as far as the eyes of the Indian courts are concerned. This judgment of the Supreme Court puts Narasimha Rao in a very unique dilemma. His second marriage is valid as far as USA is concerned, and the same is not valid as far as the Indian laws are concerned. Now, let us suppose he is having children out of his second marriage. Are the children to be treated as legitimate as per the US laws, or are the children to be treated as having only limited legitimacy as far as the Indian laws are concerned? Now, here is a question that has no clear cut answer. Why this problem has risen? The private international law that India follows and the private international law that USA follows is completely different from one another, causing this controversy. Let's take up yet another case law to understand this problem. Ogden versus Ogden, a very old case. We could say that these two cases, the Narasimha Rao case, which happened in 1991, and the Ogden versus Ogden case, which happened in 1908, are nearly a century apart. Let's see what was the position a century back. In Ogden versus Ogden, the facts are somewhat like this. A English woman gets married to a French man, P. This P was actually a minor under the French laws because he was only 19 years of age. Under French law, a person attains the age of majority at 25 years. If he wants to get married before that, parental consent is compulsory. Under English law, no such issue is there. Therefore, he happily goes ahead and gets married with his English woman under the English laws without getting permission from his parents. As soon as the father gets to know that his son was married to an English woman without his permission, he goes to the French court and he files for a case there stating that his marriage is void ab initio because no permission was obtained. The French court very clearly said the marriage is void ab initio. Now, the English woman, believing this judgment, decided that since the marriage has been dissolved by the French court, she'll go ahead and get married to another man of them. She sincerely believes her marriage is dissolved by the judgment of the French court. After her marriage to Mr. Ogden, Ogden comes to know that his wife was already married to one Mr. P. He goes to the English court and files a case saying that this woman has committed bigamy. Her first marriage is still valid as per the English laws, and without dissolving this marriage, she has got married for the second time. The English court said that Mr. Ogden was correct, and that the first marriage that this English woman has done with P is valid as far as the English law is concerned, and therefore the second marriage, being bigamous, is null and void. It is void ab initio. Again, a unique dilemma wherein she cannot get married as per the English laws are concerned because she is already married to one Mr. P. Under the French law, she is not going to be treated as Mr. P's wife, which means that she cannot claim for maintenance from there also, and she can never obtain divorce at any point in time. A rather unique dilemma which has risen because of the difference in the private international law in the English court and the French court, again showcasing that there is a need to unify the private international law of different countries. 1908 is also showcasing the same issue. 1991 case is also showcasing the same issue. Therefore, there is an overwhelming need to unify the private international law to ensure there is uniform justice no matter where a case is filed. So in Narashima Rao case, whether the case is filed in USA or in India, the judgment should always be same. In Ogden versus Ogden case, no matter if the case is filed in England or if it is filed in France, the judgment should always be one and the same. Now, this can happen only if the private international law of different countries are one and the same. Thus, there is a need to unify the private international law. How do we unify? There are actually two ways that are being suggested by jurists across the globe. The first method being unification of the private laws of different countries. For example, the marriage and the matrimonial laws of India being one and the same as that of the marriage and the matrimonial laws of USA or UK or any other country for the matter. The next scenario is unification of rules of private international law, wherein the procedure to be followed when a foreign element is present should be one and the same, no matter whether it is in India or USA or UK, wherever the case is filed. Let's take each of these ideas and explore them a little bit more. Let's start with unification of private laws. One major area wherein the private laws has been unified is the area of trade and commerce. The United Nations Commission on International Trade Law, that is UNCITRAL, observed that the Convention on International Sale of Goods 1988, based on Vienna Convention, will ensure that there is no conflict arising between the laws of different countries because all countries are going to have the same sale of goods law. So there is no need for private international law to intervene and resolve the conflict between the two laws. It has been observed by many jurists that uniform law across the globe, that is unification of the private law, is the best option to avoid conflicts, whereas unification of private international law is actually only the second best. Some conventions that have attempted to unify the private law of different countries are the Berne Convention for Copyright. In fact, India is a party to it, and our copyright law is also based on it. And there are many examples. The Sale of Goods Act being yet another example. I've given a list in this video. Have a look through it. All these laws are ensuring that the private laws are being uniform for all the countries that have put a signature to that particular convention. It is not only United Nations that is taking steps in this angle. The unification of laws also happen at the regional level. For example, Finland, Denmark, Norway, and Sweden have come together to unify certain aspects of their laws relating to bankruptcy laws or even res judicata, and much more importantly, enforcement of foreign laws of each of these countries. So if a case is filed and a judgment is delivered in Finland, the same can be easily enforced based upon this unified system in Denmark, Norway, or Sweden. A rather unique way to resolve the issue. The private laws are being uniform across to ensure that no conflict arises. In USA, each state is having its own law. To ensure that they are all not conflicting with one another, restatement of private international law is being brought out. Above all, we also have the European Union, which is a very good example of regional cooperation, wherein all the private laws are being unified and the system of justice that is being delivered is under the European court system. The best example for unification of private laws. Let's move on to the next method, which seeks to unify private international law of different countries. So, unification of private international law is something that was tried even before 1950s. In 1951, a Permanent Bureau of Hague Conference (HCCH) was constituted to look into unification of private international. Some of its main functions include keeping in touch with official and unofficial bodies that work to unify private international law, study and prepare proposals to unify private international law. It actually works under the direction of a standing commission of Netherlands in 1897 to promote codification of private international law. Some of the areas in which HCCH has brought out unification are in the field of divorce, legal separation, guardianship, international validity of a marriage, and adoption. So here the focus is mainly upon, let's say, the matrimonial laws or personal laws. In 1957, an idea was brought out with respect to that of maintenance. 1964 about adoption. 1965 for recognition of decree related to divorce. 1967 recognition of decrees related to that of adoption. Now, this is yet another mechanism through which private international law can be unified. Now, in this video, let's have a recap. In this video, we have seen about why there is a need to unify private international law, what happens when the private international law is not unified. And when we attempt to unify private international law, there are two different methods that are available. One in which you are unifying the private laws, which ensures there is globally no conflict of laws. The second variety brings out a mechanism through which the private international law alone is uniform across the globe. Both these methods are effective. With this, we are winding up today's session. If you found the video informative, kindly take a moment to like, share, subscribe to my channel. If you're having any doubts relating to this particular video, ask your doubts in the comment section. I will answer right away. With this, we are winding up for today. Thank you. Have a good day.